Hi, Frank Gray from Chesapeake Wills and Trust. Today we're going to talk about modified estate administration. What is it? If you're watching on YouTube, make sure to hit the like button for the video, make sure to subscribe to the channel, hit the notification bell so you know when we're publishing more content that'll help you with your estate planning and probate needs. All right, modified administration. Do you qualify for it? What is it? What's the reason to do it? So let's start with that last question I just threw out. What is the reason to do it? The reason to do it is because if you qualify, it can make things a lot more simple for the personal representative. You can cut out a lot of the formalities that are normally involved in probate, and maybe more importantly for the personal representative, you can simplify your life and not have to fill out as much paperwork. So let's talk about if you might qualify for modified administration. A couple of rules we have to keep in mind. Number one is personal representative has to notify the Register of Wills and elect modified administration within 3 months from the time of filing the first petition. Number two, and this is kind of a long rule, you have to make sure that your estate would qualify. Everyone has to be exempt from the inheritance tax, which means either the inheritance tax doesn't apply or you fall into one of those narrow exemptions. Or you have to fall into this really crazy definition that I'm going to put on the screen for you because I want you to be able to see it. The decedent's personal representative and all trustees of any trust are limited to the decedent's personal representative, spouse, and children, and the estate has to be solvent with sufficient assets to satisfy all testamentary gifts. So what does that mean? It means you have to fall into that narrow area of who the beneficiaries are, and the estate has to be solvent enough to make sure that all the testamentary gifts are going to be payable directly from the estate. The third rule, all of the stated persons who are involved have to file written consents acknowledging that they're allowing the personal representative to do this. Because they're doing away with all the formalities, there's not as much scrutiny, they're not going to get as much information filed with the Register of Wills, so everyone has to literally say in writing that they're on board with this. And lastly, the fourth rule is it has to be completed within 12 months. That means all of the distributions have to be capable of being made within 12 months from the time that the estate is opened. So let's get back to that last question, why you might want to elect modified administration if you fall into this category. It makes life a lot easier for the personal representative. Basically, they do away with a lot of the formalities, the paperwork that's filed along the way. Generally, the only paperwork after the initial filing that is going to be done is going to be the final report that's going to be done in 10 months. Cuts down on a lot of paperwork, but remember the paperwork still has to be sent when it goes to the Register of Wills with copies going to all of what are called the litigees. If you want more information on this topic and other topics dealing with probate, make sure to click on the link down below for our probate guide.